Hello. Um, Thank you so much for your interest in wanting to learn about the sentencing calculator that we have created for demonstrating that um, a specific defendant received an excessive sentence um, according to 701 criteria. Um, our goal today is to prove that through logic and math and through the statute that this defendant received an excessive sentence based strictly on the statute and criteria. Um, so, what we're going to do is provide an overview of the sentencing statutes and then, of course, reapply them to um, this specific case and hopefully prove that 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 a sentencing is merited or warranted here. So 13701 is pretty much the guideline, the baseline of which the other sentencing guidelines come into play. 17 the other guidelines, which are 13702, which has to do with your first time felony offender. And then you have another sentencing guideline that has to do with repetitive offenders. And then you have other sentencing guidelines for a dangerous offender. And then this, although not applicable, it is cited for dangerous crimes against children, which has its own sentencing guidelines. So 701A it says a sentence of imprisonment for a felony shall be a definite term of years, and the person sentenced, unless otherwise provided by law, shall be committed to the custody of State of Department of Corrections. B says that you cannot enter the State of Department of Corrections without a investigation report or pre-sentence report. Section C, the minimum or maximum of term pursuant to this section. So this talks about the maximum or minimum years um, of aggravation a person can get within these other sentencing guidelines. Um, this also states that this section emphasizes, the emphasis on this section is really um, about aggravating or mitigating circumstances that were found to be factual by a jury or the court, but primarily by the jury. So D here is the section that lists all of the aggravating factors that could be applied to a case. So this section here, again, is your guidelines for how you're going to be weighing your mitigation or aggravation and how you're determining that and under what grounds. So there are 27 aggravating factors that could be found in a case. And if one factor is considered 1 year, then 27 years could be added to a sentence, but it must be presented to a jury. It's not a normal that you would find all 27 aggravating factors in a case, but that any aggravating factor could increase a sentence um, must be considered here, and why it must be brought up to a jury. Um, so again, if you were to look at these aggravating factors as a year, you could add 27 years to a sentence. In section E, you have the guidelines for your mitigating and what those can be considered. What are your mitigation and how can they be considered? You notice that there are only 6 here. but 27 here. So how can any of this mitigation reduce a sentence by years if there's only 6? Our calculations do allow for the logical application of mitigation versus aggravation, and what the sentence outcome could be independent of the court's influence or um, pseudo aggravation. So whatever number the judge could decide. This here is based solely on a year of numbers that could be aggravated based on the sentence allowed by the sentencing bracket, which we will get more into. So the clear takeaways here is 13701 is your base guideline for how you sentence, how you approach mitigation, how you approach aggravation. You have to have a jury make the decision if you're going to be aggravating a sentence outside of its allowable term. So this is what you're going to be weighing everything against. So we now will go into 702. First-time felony offenders. The term for imprisonment here in Section A shall be the presumptive sentence pursuant to subsection D. So the presumptive would be 5 years here. So if you're a first-time felony offender, you have your baseline number, or the sentence that you have to begin weighing a sentence, is going to be 5 years. And just for the sake of demonstration, for the calculator, if the court is saying 5 years as a presumptive, that is what is going to be put here. That is your baseline number, 5 years presumptive. So that is where the law is telling judges they have to start their calculation from the presumptive sentence, except for those felonies involving a dangerous offense, or if a specific sentence is otherwise provided. The court may increase or reduce the presumptive sentence within the ranges of subsection D of this section. So in this case, it says that if there is a sentence that has another number attached to it or is a dangerous offense. So for class 2 felony offenders, no matter what, your sentence range is a 3 to 12 if you find any mitigation or aggravation. So to begin, it would be 4 to 10 years. But if that class 2 felony is an armed robbery, and that armed robbery is considered a dangerous offense, then the sentence range is going to change. The mandatory minimum is what it's also called. So although under 702 first-time felony offender, your sentence range can fall within this bracket. If mitigation is found, you can go as low as 3 years. If aggravation is found, you can go as high as 12 years. But if you're just beginning as a judge for your baseline sentence, you're going to do it a 5. But if the offense is an armed robbery and is considered a dangerous offense, then the sentence or the presumptive will begin at a 10.5 if the judge has not found any mitigated or aggravated at the penalty phase of the hearing, or if the court did, or if the jury did not find. So that baseline will be between 10.5 years and 5 years for an armed robbery. So it all depends on whether mitigation or aggravation was found and where the judge wants to begin the baseline sentence, but it cannot exceed 10.5 or 5 years, or go beneath 5 years. So that explains what this means here is unless a specific sentence is otherwise provided, the term of imprisonment for a first felony offense shall be the presumptive sentence pursuant to D, unless there's a dangerous offense or the sentence is specified otherwise. And it must fall, and you must get your numbers or your mitigation and aggravation from 13701, which again is your base here. What else do I have to say about D701? Okay, yeah. So again, first time felony offenders, this is your sentencing bracket for class 2, class 3 felony, which is the case with this person. Any reduction or increase shall be based on the aggravating or mitigating circumstances. It states right there, any reduction is based on that. So if we any reduction or any, so if you found any of the 27 aggravating factors here, any of them, or any mitigating, in this case, we'll say we found 2 aggravating and 1 mitigation. Your aggravated sentence would be 7 years. Your mitigated would be 4 years. Your presumptive in between the two would be 6. We'll get more into that. But again, it's really just about how it's adding and increasing and decreasing towards the sentence. B, if a person is convicted without a previous conviction, if there's no prior felonies, and 2 aggravating factors are listed or found in the 13701D, so any of the 27, the court may increase the max term to an aggravated unless authorized. So the court may increase the maximum years to aggravated if 2 aggravations are found. If you found 2, then you can. If 1 is found, you cannot. But the same is said here is if you find 2 mitigation, you can reduce the sentence from the presumptive to 4 years if mitigation is found. So again, this is how things are being measured. So if convicted without previous convictions, the court may increase the max term to aggravated. 2 mitigations exist. The judge may sentence the minimum term. So in C, in pursuit to first-time felony offenses, within this section may be imposed only if the aggravated or mitigated is found to be true beyond a reasonable doubt. So again, these any aggravation or mitigation imposed has to be found to be true without beyond reasonable doubt. And it should be brought by a jury. This cannot just be something that is pulled from the list of aggravating and stated as aggravation without full consideration of a jury. 703 has to do with repetitive offenders. And the reason we are mentioning it here is more so because this is a crime spree that the defendant was involved in or allegedly involved in over a period of 3 days. And so although the defendant states that this was a crime spree and should not have been treated as if it was separate offenses or separate convictions, and he should not be held or sentenced as a category 2 or 3 offender, in which he believes he was. we are going to talk about repetitive offenders and how the law should be applied or in here and should be fixed. So if a person is convicted of multiple felony offenses that were not committed on the same occasion, but that are consolidated for trial purposes and are not prior felony convictions, the person shall be sentenced as a first-time felony offender pursuant to 702. So again, this person has to be within this bracket, even as a first-time felony offender, even if they have multiple felony offenses. So the first offense and category 1 offender, okay, so that tells you that there. So except as provided in 704 and 705, dangerous offense classification, a person should be sentenced as a category 2 or 3. So this just kind of gives you when a person should be classified as a category 2 offender or a repeat 3 offender. These are for more serial offenders. This does not apply to our person that we're speaking of today. For 703, again, you have your guideline or what your numbers should be based on mitigation and aggravation. So the presumptive term set by this section may be aggravated or mitigated within the range under the section pursuant to 307 or 13703. So this right here is giving you your baseline number. So what the judge should be deciding your sentence from. And if they found aggravation or mitigation, then it could start at as low as that number. So if we were to go back over here and say the judge found mitigation or aggravation, that number then can be applied here in the reverse. And it changes the sentence based on the aggravation or however the judge sees fit. And there's different ways that this scenario can be applied. We want to do our best not to over apply the scenario, but just do it for the sake of demonstration, because this will differ for case by case. Our demonstration doesn't want to go so far outside of this case that it then changes how this calculator can be used, which is dynamically in many different ways. But for the sake of this repetitive offender demonstration, 703, the presumptive term is the defining number for the sentence range for the defendant. And in this case, again, he should still be classified and sentenced within the sentence range. All right, 704 is dangerous offenders. So except for whatever is stipulated in 705, which is inapplicable here, a person who is at least 18 years of age and has been tried as an adult stands convicted of a felony that is a dangerous offense shall be sentenced to a prison term of. And so again, that was part of the armed robbery sentencing range, which was the most severe charges of this crime spree was an armed robbery. There were 2 charges of armed robbery. The defendant did receive a 10 point or a 10 just over a 10.5 year presumptive sentence. That sentence, regardless, shouldn't exceed the 21-year sentence, and the judge makes sure that doesn't happen when it runs the sentences concurrent. So the 2 armed robbery charges for 2 separate occasions were run consecutive and do not exceed the 21-year maximum allowable charge. So on the surface, our defendant does seem to be within the 21-year bracket of dangerous offenses. But as we will demonstrate later, the theft then violates the integrity of the 21-year maximum term allowable for the totality of his sentence, of which we will demonstrate um, as to how aggravation was misapplied without being heard. So 704, again, this is a sentencing guideline or bracket of which um, our defendant should have been sentenced under. Okay, so this is part two. Now we're going to get into the sentence of the defendant, and what that looks like, and with visuals. So just to recap, 13701 gives us our 27 aggravating factor guidelines, of which could be used to increase the sentence. 13701 also in section E talks about the different types of mitigating factors that could decrease a person's sentence. It takes into consideration victim impact. And even if the jury does not find two aggravations, or if two aggravations are not found beyond a reasonable doubt, again, for recap purposes, if two aggravation factors are found, the sentence is opened up to churn the sentence from a maximum to an aggravated sentence. The same could be said about mitigation. If two mitigations are found, then the number can be reduced from the minimum allowable term to the mitigated allowable term. But if only one aggravating factor is found by the jury, it is possible for courts to find other aggravating circumstances to aggravate the sentence based on the preponderance of evidence. But again, the court cannot sentence individuals outside of the maximum, minimum, aggravated, mitigated sentences prescribed. And the baseline number that judges are supposed to use for getting their sentences is the presumptive sentence as stipulated in 702. 702 gives you the number that judges are supposed to be using to begin determining the sentences after aggravation and mitigation has been presented to a jury. Our calculator does pull into consideration if one aggravation or victim impact. Again, 701 is your outline or your criteria for where you are going to start measuring your sentences. 702 is going to give you your baseline number, your presumptive, the number that you're going to begin increasing or decreasing the number based on aggravation and mitigation. So 702 is your authority. 702 is also your authority about whether or not you can aggravate a sentence based on multiple felony offenses, and how much can you aggravate that sentence within the sentence bracket. If you're a first-time felony offender and you have multiple felony offenses, but they're not prior convictions, they have to still continue. They have to be treated still as a Category 1 repetitive offender, and you still have to be sentenced within the baseline number, presumptive number provided, and within your felony bracket and within your mandatory minimum bracket, which would be an armed robbery. 13703 is all about the repetitive offenders. So even if there was any question about what is a first-time felony offender and what is a Category 1 repetitive offender when they are not serial offenders and do not have prior felony convictions, Repetitive offenders, again, if you do not have serial convictions and you do not have prior convictions, and there's no court that has found anything other than the offenses at hand, you have to be considered a category 1 offender, and your sentence cannot go outside of this bracket here. And any sentencing within the repetitive offender goes right back into 13701 and how you're getting your aggravating and mitigating factors. You're getting them from your 701. That's how you're measuring them. 702 gives you your baseline number that you start your measuring. And for repetitive offenders, again, your baseline number is going to be provided for you in the sections given. 704, dangerous offenders. So even if you are a class 3, class 2 felony offender, but you also have a mandatory minimum, certain offenses carry a mandatory minimum, like armed robbery, you are going to have a bracket number to begin from 7 to 21 years. But again, if aggravation and mitigation are found, that number can be reduced. But your beginning number will be your presumptive number. If I've said anything different on the other recording, please forgive me because I did catch some typos. I stand corrected here. Yeah, so alrighty. And then we are going to get into his actual sentence and what happened here. So quick recap again, if you are a class 2 felony, first time conviction, this is your beginning number, minimum, maximum. If aggravation or mitigation is found, then it opens up the door for these numbers here. If it's a class 3 felony, this is your presumptive number or your beginning number. If you find mitigated, your minimum sentence can now go down to 2 years. If aggravated is found, your aggravated sentence could go up to 8 years. As a theft, as a class 3, it's a class 3 felony, theft with a 4,000 to 25,000 monetary value range. You're going to be sentenced within your beginning sentence is between a 2 and a 7. If mitigation or aggravation is found, it could go this high or this low. Same for theft of means of transportation. It's also considered a class 3 felony. This is its sentencing range. Armed robbery, it is considered a dangerous offense. It carries a mandatory minimum sentence. But if aggravation or mitigation are found, then the sentence can be reduced based on those numbers up and down, but it cannot exceed the 21 years. And you would base your number based on the 10.5. So what happened in this case, again, for armed robbery, your sentencing bracket is going to be 7 to 21 years, or here. He was sentenced to 10 years, 7 months. He was sentenced 1 month over the presumptive or the maximum. So he was aggravated. Yeah, he qualified. That it's not relevant right now. So it is relevant, but not relevant. First degree burglary. This was his sentencing range. As a class 3, there is no reason for it to be a dangerous. This was the sentence he received, 10 years, 7 months, 1 month over the presumptive. So far, seems fair. Then for the second armed robbery, he could have been sentenced within this range, even as a category 1 repetitive offender. Well, no, category 1 repetitive offender. Um, for the armed robbery here, he received 15 years, 9 months, which is 5 years and some change over the presumptive. No mitigation seems to have been considered because because the sentence only increased. So it's excessive by 2 years, 3 months. We don't know how we came to aggravating factors here, three here, three here. So yeah, so we're not understanding where the justification for such an aggravated sentence came into play. Um, although it still doesn't take him outside of the 21-year maximum allowable for armed robbery. Same. So then the second first degree burglary, again, received 15 years. So over here, it was the first two charges of it were 10 years, 10 years. They then became aggravated here, even though it was supposed to be a category one. We're not sure how the aggravated number came to be so high here that increased this sentence. But here is the automatic grounds for resentencing, and where we require justification and clarification of the sentence. Because for theft, you can receive a minimum of 2 years to 8.75 years if aggravation or mitigation is found by a jury. In the event that none on either side is found, this is your sentencing range. In this case, the theft here, he was sentenced to 11 years, 3 months. 3 years, 3 months over the aggravated sentence term. Allowable on the first time felony offense. And then the court ran the sentence consecutive. So from the presumptive, which was the baseline sentence that the court should have been considering this sentence. From the presumptive, the court had to find some mitigation or aggravation to justify a sentence of 8 years. None has been presented here. What we have here is this sentence being aggravated to from 3 years all the way up to 11 years, about 8 times, over 8 years. 8 times this sentence was aggravated. 9 times when you run it consecutive. And it was outside the allowable aggravated sentence. By running this sentence consecutive, makes the sentence 21 years and months. The maximum or most aggravated allowable sentence for the overall armed robbery was 21 years. The court violates this when it runs this sentence, illegal sentence, consecutive to the armed robbery charges. Because the maximum allowable sentence for this individual is 21 years. And the court, without going through proper procedure and providing the defendant its due process right of a mitigated and aggregated hearing at the penalty phase, he should have been allowed to present that, because this number would not have come in. The sentence would not have been aggravated to this extent. And then it's further aggravated again for the theft of means of transportation. Again, same scenario. He was sentenced completely outside of the allowable term. The sentence was aggravated at least 20 times over again, and the court cannot justify this sentence when looking at it as in its totality as a crime spree. So, to put a better example in demonstrating the theft, let's assume that in this case, the court found two aggravating factors, which was um, the presence of an accomplice and that the victims were 65 years and older. Um, we will assume that the aggravation is applied. So for the theft of means, the presumptive number according to the statute is 3.5 years. That is the number that we will begin to be running again. That we will begin running this sentence against. 3.5. With two aggravating, and we'll put one mitigation for him, his age. We could add more, his role. Let's do that. His role. Minimum role. He wasn't even part of the taking of the car. So let's say that the presumptive is 3.5. He was aggravated 2 points, accomplice, and the age. So without any mitigation, the sentence could be increased to 5.5 based on that aggravation. By 2 years, the sentence has been increased. With mitigation and those factors, his sentence could go as low as 1.5 if mitigation was found. With mitigation and aggravation, his sentence is 3.5. So he stays within the presumptive range. It doesn't change. So mitigated without aggravated, 2 years or 1.5. Aggravated, 5.5. If you were to count a victim impact, more. Again, if we were to either way, the number doesn't change so far out that he ends up with an 11-year sentence, even upon aggravation, and then to run it consecutive. We would need justification as to why the aggravation made the sentence 8 years more than what it should have been from the presumptive sentence. Which of the 27 aggravating and which of the mitigating did not calculate? This sentence is clearly excessive. If we run the armed robbery, if we were to run this sentence, run his armed robbery as if from the 10.5, with the 2 aggravated, he could get as much as 13.5 years, as Um, 8.5 with mitigation and no aggravation. But his ultimate sentence is 11, 5 years. How did the court get 15 years with no mitigation and all aggravation? How? The criteria set forth in 701 is right if applied right. It is fair if applied fairly. In this case, the sentence was aggravated, so much so that it does shock the conscience when it is sentencing outside of the allowable sentencing ranges, and when it is applying aggravating factors without justification and without juror consideration. In this case, the state alleged prior felony convictions, put on record that it was going to aggravate this sentence in any way, shape, or form that it could, that the law would allow. And even in looking at what the law was allowed, it was not allowed. This sentence is clearly excessive. And what we are asking for is the opportunity to provide a full demonstration based on case law, um, based on the statutes, um, that the sentence is excessive. Thank you so much, and I look forward to hearing from you.